My name is Max Frislone, and I'm a criminal defense attorney in Maryland. A good portion of my practice focuses on DUI and DWI cases, and the purpose of this video is to answer a question I get often during initial consultations. What is the difference between a DUI, driving under the influence, and a DWI charge in Maryland, and why am I charged with both? If you're watching this video from outside the state of Maryland, I recommend you consult a local attorney in your state, because drunk driving laws are different in every state. There are going to be two main sources of differences between DUI and DWI cases in Maryland. Those are going to be the maximum penalty and the elements the state needs to prove their case. Let's start with the maximum penalty. Both of these charges are contained within Section 21902 of the Transportation Article. DUI, driving under the influence, is contained within 21902A. It carries a maximum penalty of 1 year, a $1,000 fine, and 12 potential points added to your license. A DWI, a 902B offense, carries a maximum penalty of 60 days of incarceration, a $500 fine, and 8 points assessed to a person's license. So as you can see, a DWI is a lesser charge than a DUI. The second place that we're going to see a difference between the two is in their legal definition, the things the state must prove to a judge or jury beyond a reasonable doubt to earn their conviction. The place that we can find those answers is in Maryland's pattern jury instruction for criminal cases. The pattern jury instructions explain the elements for each offense. Both DWI and DUI share the same first element, and that is the state must prove beyond a reasonable doubt that a person was either driving or attempting to drive. The second element of a DUI or DWI case is where things get different. In a DWI case, the state must prove that a person was impaired, their normal motor function were impaired by alcohol. A DUI case carries a higher burden of proof. The state must prove a person's normal motor functions were substantially impaired by alcohol. Practically, how does this play out? I've seen in my experience that both judges and juries alike often convict on the DWI in close call cases where they didn't feel a person was substantially impaired, but that they were to some degree. States' attorneys' offices throughout the state often offer a DWI as a plea in cases where a person refuses a breath test. There's also DWI pleas offered in some cases where there's not a strong presence of alcohol or a person doesn't admit to drinking. But these facts are going to be specific to your case, so feel free to call our firm for a free consultation and we can discuss how your case might apply and why you may have been charged with DUI, DWI, or both.